Shamani, would you take the roll, please?
Of course. For the State Treasurer, Mr. Boykin. Here. For the Director of Finance, Ms. Ortega. Ms. Higa. Here. Ms. Dillon.
Here.
Ms. Hendricks.
Here.
Mr. Rosensteel.
Here.
And Controller Yi. Chairperson Keeley, you have a quorum.
Thank you. So it's 2 p.m. We're going to be working through the afternoon, and then tomorrow we'll kick off our day, continuation of the board meeting, where we will start the morning with our interviews with fiduciary counsel, 3 applicants that have made it to the finish line. But that will start tomorrow morning. That will be the opening of our day. So this afternoon we have a handful of items to get through, making sure we keep a nice rhythm and pace so that we're fresh for tomorrow morning for those all-important interviews with our fiduciary potential candidate, future fiduciary counsel. So with that, item number 1 is the approval of the board agenda.
So moved.
Second.
It's been moved and properly second. All those in favor?
Aye.
Thank you. Item number 2, I'll turn over to our CEO, Mr. Enos. Jack Enos will run the elections for board chair and vice chair, and I was assured that there wasn't any politicking that went on prior to the meeting.
Good. All right, I look forward to this every year. This is your annual officer election. It's required actually by statute. And there are no other further restrictions on that other than you shall annually elect a chairperson and a vice chairperson. Once we complete that today, then we proceed with your interests in committees next month so that when you start the fiscal year in July, you have officers in place and your new committees are in place, and we do the business plans in July. So we'll start out with opening the nominations for chair of the board, and I'm asking if there are any. We have a hand raised there by Dana Dillon. Dana?
I'd like to nominate Harry Keeley for chair.
The nomination of Harry Keeley for chair of the board. Do we have a second? We have a second from Paul Rosensteel. Are there any other nominations for chair? Seeing none, we'll close the motions, and I'll ask that all in favor of the motion, please say aye.
Aye.
Oppose? Congratulations, Mr. Keeley. You are back on board again. All right, and then similarly, we have nominations open for vice chair of the board. We have a hand raised once again from Dana Dillon. Dana?
I'd like to nominate Sharon Hendricks.
So we have a nomination of Sharon Hendricks for vice chair. Do we have a second?
The only thing I'm
we
here
have a
for.
second.
The only thing I'm here for today.
Do we have a second from Joy Higa? And do we have any other nominations for vice chair? Seeing none, the nominations are closed. All in favor of the motion, please say aye.
Aye.
Oppose? Congratulations, Sharon. Back to you.
Jack. So just a couple of comments before we continue. I'd like to thank the board for your confidence in Sharon and showing your confidence in Sharon and myself. As chair of the board, it's a tremendous responsibility that I take very seriously. A couple of things that I would hope that we can continue to do and reflect and more importantly embody in who we are is be a board that is collegial in nature. And that doesn't mean we always get along, but that we're collegial and collaborative. That first and foremost is something I hope to continue to establish and create. Secondly, I would hope that we are a board that leaves our titles and the avenues by which we got to the board outside the boardroom, and that we come in here as board members, and that it's our diversity of background, diversity of thought, diversity of opinion that will lead to sound decision making, and that I'm a big believer in that the world's full of problems, and the world's full of people who want to complain about problems, but it's lacking in leadership in terms of identifying the solutions. And we certainly have our challenges ahead of us and a huge responsibility. So solutions are what we're looking for, ideas are what we're looking for, and that we'll work with our staff and our consultants and others to implement ideas that will sustain the CalSTRS fund well into the future. I love working with Sharon. I respect and admire everybody on this board. I thank you for what you've contributed to my life and how you've continued to push and challenge me to be an effective board chairman. Having said that, I'll try to be more efficient as well. Because that's clearly something we want to do.
Clearer
So-
That's our direction.
Adopt the fiscal plan 215-16, which is some direction. Thank you, Dana. For 15 and 16, that's the calendar for next year.
Yeah.
And Danielle has worked on this, putting this together. It still reflects the Wednesday, Thursday, Friday meeting format that we have been used to. We thought about making some adjustments and going to Tuesday, Wednesday, Thursday. Some of us have real challenges around that Tuesday. It complicates things for us. So Wednesday, Thursday, Friday were the days that work best. But taking into consideration your input, we'll be working with staff so that the Wednesday meeting will likely be the investment committee. Thursdays will be the board meetings, and then Fridays, the subcommittees. We want to really honor that Friday, being able to, for those of us that need to leave earlier on Fridays for different reasons, we can do that. So it's a little bit of a compromise. We're not going to move to a Tuesday, Wednesday, Thursday, or a Monday through Wednesday. We're sticking Wednesday through Friday, but when the committees meet, will be flipped. So if you're not on a subcommittee, you'll be leaving Thursday night or early Friday morning. So take any comments for this, Mr. Rosensteel.
Yeah, just one comment, because I think that this, there's a lot of tentative dates on here. And I think going to the website for like this year, it still shows basically what was initially adopted. So as decisions are made as to whether there's going to be a meeting happening or not, I'd appreciate it if this could be updated so that we always have an up-to-date schedule on whether we've got, a meeting scheduled or not, because these tentative dates sometimes hang around for a long time and maybe beyond when we've made a decision that we do or don't have to have a meeting.
Yeah, I was thinking we took them off as we move through them, but there's still stale dates on there. Danielle used.
I think
But I agree with you. We definitely want to do that. As we make a decision, it's got to go off. Yeah, because we don't want the audience thinking there's a meeting too. I'm with you, for sure. We'll make sure.
Thanks, Jack.
Yeah. And then just,
Before
yeah.
let me
go.
take Mr. Unterman first, Jack. Thanks. Mr. Unterman?
Well, first, I appreciate the changing of the committee schedules and working on trying to free Friday afternoons, because Friday afternoons are a travel mess and create other difficulties for people. And just eyeballing the schedule, one thing did catch my eye, and this might be a retiree perspective on things, but meeting that right before Labor Day is probably not the most conducive time to meet, and to put us all traveling on Labor Day weekend is also probably not a great thing to do. But my experience is the week before Labor Day and the week after Labor Day is a time when a lot of family vacations are planned. I will admit that I don't know what my family's planning for September yet, but I'm sure the other half of my family will tell me shortly.
So, that's a good point, and I caught my eye, actually.
That's the hardest month to schedule that far because it's
September.
CalPERS board meeting in that other week, I know.
What is the other week of the CalPERS, Jack?
Well,
September
September's always the
Oh, I
toughest
see.
one. We always I don't have a good answer other than, I agree with you. True for our families here too, the same issues. But that week of if you go to the week after Labor Day, that 15 to 17, as you can see, Danielle's noted that the CalPERS board meetings got those days locked up. Yeah, or we could do the last week of August. That's a
Why don't we
possibility.
do this, rather than try to like tinker with the calendar right here, right now? That's one area that we can try to accommodate and see if that month we can do something that's a little bit more conducive to everyone. Does that mean we just don't take action on the full calendar, or we can take action and then we can amend it?
Oh, you can change it.
Yeah, so why don't we just flag that week, where that's Labor Day week?
Sure.
If we can make adjustments, something, if that's possible, may not be, maybe we move it to Tuesday, Wednesday, Thursday, it doesn't, It doesn't solve the week problem, but it takes us out of that Friday. And those of us have a challenge on Tuesdays can plan for that 1 month where we can work around that. So we'll do that, we'll flag that, and then we can communicate out with the board electronically around this issue, September. The other area,
Excuse me, Harry.
yes,
I
go ahead,
mean,
Tom.
And again, this is something that other boards I'm on are conscious of as they try and schedule, and as a result, every board tries to schedule on the same days. But if you took as a practice trying to avoid the week before or week after a 3-day weekend, you're usually going to minimize things. That would, of course, raise a question about July also, but I'm not sure what you can do about it at this point.
Well, speaking of July, I've had one board member's already approached. We have 2 days flagged. Already heard from our CEO that it's unlikely we're going to need 2 days. So is there any opposition to us just holding the 9th and not that 9th would be the primary, that would be our day? And not have to meet on the 10th unless for something unforeseen bubbles up. But we would have a full day on the 9th, which is a Thursday of July, and we'd clear the Friday. Is there anybody who has a pressing issue with that? Okay, so why don't we make note of that change, please? And then are there any other issues that surface at this point relative to the calendar? Okay, so seeing none, I'd entertain a motion to approve the calendar as it's been presented, with the full understanding and acknowledgement that leadership will work with staff to look to see if we can accommodate the September issue. So, okay, it's been moved and properly second. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Okay, thank you. Let me see if I can pull it. Our next item, I believe, is the education item.
Yes.
Okay, so I'm going to present this item here. This is an item that has to do with board member education and travel. The reason this item is before us is that it's just come up as an opportunity to really refresh for the board and for the public the different types of travel that we engage in. The item itself is very self-explanatory. I think what should be noted in our travel, the opportunities to participate in different learning activities are very meticulously screened. And our CEO and senior staff provides for us some opportunities to attend so that we can expand our knowledge and improve our effectiveness as board members. So there's several different categories of types of travel that are involved. The dollar figure, which is in the item itself, has remained at that level of $60,000 per year. And I don't think, Jack, we've ever, rarely do we reach that threshold. We reach one time. So we're quite selective in when and where we travel. That's important. The other important component to this is that there's always a self-reflection that the board does on the travel that we participate in, and any reimbursements that we receive are only released after the self-evaluation takes place. So the question before us really is this the right type of, is this the level of transparency that we want? Do we want to increase that transparency? Do we want to modify or adjust the dollar amount that's adjusted for, that's allocated for the travel and educational opportunities? Or are there aspects of this that need to be changed? Anything that I left out, Jack? Anything you want to highlight?
Not really. I mean, the current approach of disclosure reflects kind of an iterative process with the board. Different board members wanted to see different things and different things reviewed. So it's kind of where you stand with the current board, if this is working for you. Also, I think it underscores the level of responsibility of being a board member. It isn't just about travel that's on this page, but it details all the things that board members are involved with from a time perspective too. So it is, I think that's important to see that when you see all those pieces laid out.
Mr. Boykin?
Thank you, Mr. Chair. So as controller and now as treasurer, Treasurer Chung has been pretty consistent in his sentiment that more disclosure, more transparency is always better than less. So, having laid out these options, of course, his bias is, hey, let's take all of those categories, not just the travel for conferences, but also the more work-related sort of categories too, and possibly think about creating a budget that reflects all of the board travel, not just for educational conferences, and sort of expanding the list that we disclose. Having said that, I think we're very transparent with our travel and the fact that we do have a budget, and it's part of our October offsite every year is to reflect on how we've used that budget. But that's the treasurer's feeling is, hey, let's add more.
Ms. Shi.
Thank you, Mr. Chairman. I wanted to see if there was any openness to including disclosure of meetings with investment managers. I have a feeling this is going to be probably of interest to more of us to do, and generally, I would assume that the presentations that are made aren't ones that we would hear as a full board, and so I think disclosing that, and there's an opportunity to even have feedback from board members who have availed themselves of those opportunities would be.
So I'll just add a little insight into where I've taken advantage of opportunities to meet with critical partners has generally been when I've been traveling for other conference-related events. For example, it might be in New York City. It's a perfect opportunity to sit in and meet with managers and our staff to do a great job in setting up those appointments with key figures within those firms. And generally, those are very large managers, long history with those managers. And the nature of those meetings have always been around the macroeconomic views of how they see the world, how they see fiduciary duty, how they see boards operating, what their view on the global economy is, where they see opportunities and risks. Provides a great opportunity to sit down and talk with thought leaders and investment managers about their insights, which then can contribute to how one thinks about the work that we have to do. Generally, I try to set those up for times when I'm centrally located. And I usually send questions to staff in advance who then forward it to the folks that I'll be meeting with where I've availed myself of the opportunity, so that conversation is all set up. And they've always been quite good. And you get a real sense of the different cultures in the different asset classes, and then within those asset classes, the firms themselves. But generally, they're large relationships that add good insight. So, but I do think disclosure of any other meetings that occur can and should take place, but in what format, I would refer to maybe Brian and his team, how we do that, et cetera. I hope that helps, Ms. Yee. Gives you a
Yeah,
little
no,
insight.
and I'm not discouraging any of that from happening. I think
Yeah.
it's all very enriching for any one of us or the board generally. But it's the nature of the relationship we have with investment managers, and whether it's appended to a conference we may be attending or otherwise, I just think disclosure would just add some transparency
Absolutely.
that people would want to know about.
Terrific.
We'll come up with something that works, a reporting mechanism that works on that. And then the only other thing I might suggest is the individual board member or board officer may want to report back to the board generally of what took place, or what insights were learned. But that could be on
Perhaps
a,
you and I can talk a little
Yeah.
offline about
Okay.
being
Yeah.
responsive to this request that meets the needs of disclosure and what would be the appropriate way to do that if
Yeah.
it's different than the forms we currently have.
absolutely.
Okay,
Yeah, that's,
great. Anything else, Ms. Shi?
that's it.
Thanks. Ms. Ortega?
I just wanted to state my support for the comments that have been made, and in particular, the item number 6. I also thought that we should focus on having more, possibly more, maybe that we're already doing it in some way, but disclosure of that part of it. And I think the questions on TRB 10 are kind of, should the board be approving more of these items? And I don't, in my sense is that it's not approval, it's it's transparency, because
Right.
I don't think,
Providing
I think we all are, there's a expectation that board members are only traveling when appropriate and attending and behaving appropriately, so I don't think it's an approval, but it needs to be a way for the members to know how the funds are being used, if funds other than the education budget are being used, and also for other members of the board to know what meetings might be going on. So, you know, if we're discussing an issue as a board and two members have been to some event that the rest of us don't know about, it puts us in a strange position if the full board hasn't been made aware of, you know, meetings or relationships or discussions that have occurred. So I think the transparency helps for both of those, the discussion and then also the use of the funds. So I support whatever kind of conclusion we might get to on that.
Mr. Boykin?
I didn't.
Nope, you're out. Mr. Rosensteel?
Yeah, I just want to express support as well. I think especially the meetings with investment managers, even if we're having conversations with them about global or macro issues as opposed to their own business, there's still definitely, they're probably appreciative that we've given them that opportunity to
Right.
speak to us, and some of their competitors might want that opportunity too. So I think it's also just important to make sure that there's disclosure, so that nobody thinks that that people are getting an unfair advantage or anything like that too. So I think that's a very important thing to have.
Ms. Yee?
Just a question about the $60,000 annual budget for this. Has this been consistent for a number of years, or?
It's been almost the entire time I've been here. When we started out, we did surveys of other public pension systems, how they budgeted for trustee travel. As you might expect, there is no norm. Sometimes it's X dollars per person, sometimes it's X trips per year, sometimes it's this and that. This board decided not to be so micromanaging of each individual board member's travel, but to have a global budget. So the magic of it is 12 times 5. So originally it was set up as 12 board members and about $5,000, but recognizing that some would do less and some would do more. So that's the magic of the 60, and it's turned out to be an adequate budget for all years but one.
I guess the question is, are there opportunities that aren't being pursued because we are limited by the budget? And I'd be open to looking at a potential increase if this has not been changed for a while.
Mr. Unterman?
Yes, on the subject of meeting with investment managers, I would urge a practice of extreme restraint on the part of board members. One, because it's in the nature of the game for managers to want to get themselves between us and the staff. Two, the added educational opportunity is really limited relative to what you can glean as to these very topics in public educational settings. Three, the implied competitive advantage that a manager may feel is one thing. The other thing is their ability to advertise an ongoing dialogue with the CalSTRS board in their fundraising is something I think we want to discourage. So my reaction is it's something for us to leave almost exclusively to the staff. And I'd really urge that on other members.
Ms. Hendricks?
So I have two things. I guess I wanted clarification maybe on when we say investment managers. I'm assuming we're talking about people we already have relationships with, right?
Perspective.
Okay. So one thing that I know in talking to different board members, thinking about education, I know, and this is sort of, I went to San Francisco to meet with our consultant, and Paul and I visited a couple of real estate holdings that CalSTRS has. And I found that to be a very educational experience because I got to actually tangibly see CalSTRS, real estate holdings, and then have a little bit more offline conversation with our real estate consultant. So in that context, that was very educational to kind of have those are, I guess, relationships we already
Sure.
have, right?
Yeah, no, that's.
So is that
that's not
kind
the-
of, so
no,
that you're
I'm-
talking
I'm-
about,
I'm thinking, oh, hi, KKR, I'm in town.
Right.
Can I come in and have a cup of coffee?
yeah,
Or,
okay,
hi, I'm from KKR, I'm in town. Can I come in and over and have a cup of coffee?
good, okay, that's helpful.
And KKR was just a name I picked out of the blue. I-
They didn't call you for coffee
Yeah.
recently? Okay. No, that's helpful to clarify. So I would agree then with all those comments and I know, I agree that it's, so. The second piece I wanted to just, sort of circle around with is, Ms. Yee's comments. And I do think that, one of the questions I had was with the $60,000 limit, how does that interplay with the new requirement we have for board members' education, the 24-month, is it 24? We just talked about, it, the requirement, the threshold that we have for board members in education now, because I do know there's various ones of us that take advantage of some of those educational opportunities, and now that we're sort of making it,
That should put more pressure on
every
that, I
year
would
at
think.
least one educational item, and I did wonder about
Yeah.
the implications for the fund and,
Yeah, I think that's a
If we
reasonable
should
caution.
consider
That may
that.
put pressure on that budget to the extent it involves travel. Yeah, I mean, we can obviously watch it and, I mean, this is an internal reallocation. It's not a request of
Right.
the legislature, so,
Right.
I mean, to the extent you feel you're bumping up against
Yeah.
it, we can present that to you and you can, I'll internally reallocate, set the budget higher. But I just want to make sure I leave to just, so it sounds like unless there's more to come, you don't want to change the overall approval process. I didn't hear you say that, Harry, right?
No, I think but I'm going to hear what Mr. Zeiger has to say, and then I think there's a couple of,
Okay.
just try to
I'll
summarize.
wait till
the
you're
whole-
done.
Yeah.
Got it.
Okay, Mr. Zeiger.
Just two quick things. One is that, letting people know what we've done, I don't think is a bad thing. So in general, transparency around saying, what activities we've been engaged in, particularly with outside folks, is probably a good thing. And secondly, it's been my experience that people are really judicious about what they choose to do on the board and the activities and there's a variety of interests. People do very different things, and that, I think, has been good for the board overall. So that there's been quite a bit of exposure. We're not often at the same events at the same time. I mean, that's really unusual. We've got one event coming up where several of us are going to be there. That's the exception, not the rule. And people do different things, and I know most of my time has been spent in educational institutions because I thought that was important for me to get that underpinning. Other people are doing other things, and I think that variety has been just sort of all on its own, organically, has been pretty sound.
Mr. Unterman. And I think this may be the last comment on this issue, and we'll get moving
you're so
along.
efficient.
Just a comment on the $60,000 limit, which my guess is there could be pressure on, but the other side of it is being on the West Coast, which is, there's for almost every program given on investments and investment activity, there's the East Coast and the West Coast counterpart, and you can probably get there pretty easily. And if it's not in San Francisco or Los Angeles, it's in Las Vegas. So,
So
Thanks.
Us being in Las Vegas.
just a couple of, before we approve this item, because it's an action item. Key points were, look at how we're reporting out and to improve, to the extent that we can, greater transparency. Secondly, is to continue to use extreme discretion when board members are meeting with managers that we have relationships with. That discretion is the key. Reporting back to make sure that the full board is aware of what board members, which board members are attending what events, aside from what's not already in the agendas and made public. And that 60,000 threshold, if we get pressure up against that, that's certainly something that can just come back to us that we look at. I don't think I missed anything else. So discretion, disclosure. Tom?
when you were speaking, it triggered one other thing that I think generally we should avoid in the education There are frequently private conferences that the investment managers put on and host people at very nice places. And my sense is we should avoid those, attendance at those.
So those types of events.
They're educational.
Yeah, they're educational, and like you said, they're generally held at in nice venues. And when those opportunities,
And they fly you there.
well, that I think
Well,
we're
that's
opposed to
enough.
that. We don't do that.
No, we don't do that.
No, not us.
I'm just
All of-
kidding.
Yeah. But all that is also, when in doubt, I would encourage my colleagues to pick up the phone, speak to Brian, who will put us in touch with Tiffany in his office, if there's any disclosure requirements that are required by the State Ethics Committee, Form 700. That's always a good rule of thumb, is just pick up the phone, talk to Brian, talk to Tiffany. That's another form of disclosure and transparency that we embrace. Okay, so we need a motion, one more. Ms. Ortega.
Sorry, just
That's
one,
okay.
so I can respond to that. And I know all the board members know this, but for the folks watching, I think our internal website has the list of events that, Jack, I think you look closely at. And so there's recommendation from staff about the best conferences, the ones that give you the most value for your time and the expense. And so I think as long as we always have that in mind, we can choose the events that will be the most valuable to our members of the fund.
Thank you, Ms. Ortega. Seeing no other comments, this is an action item.
Well, we're really just approving the travel that's on the last part of the
Thank you,
document. We're not approving any of the
Anything,
policy
right.
changes.
Yeah, so it's just approval. Do we need a vote on that?
Yeah, normally it's part of your consent agenda, but today it isn't, so you do today.
So all those in favor of the approving the travel arrangements that are, yeah, motion to approve, please.
Second.
Moved and probably seconded. Don't think there's any other comments. Those in favor say aye.
Aye.
Okay, thank you. Very good. All right. Thank you, Jack. Thank you. This is item 5.
I think I'm doing that one.
Is that you, Jack? Fiscal year budget fiduciary insurance?
I'm doing that one too. This is just a minor issue, but you're about to open up the fiduciary insurance conversation in just a minute, and we wanted to make sure our budget was correct for making those expenditures for the overlap that we have from the old brokerage and then the new brokerage coming on. This comes out of our continuous appropriation, not our normal operational appropriated budget. So in order for me to have the right amount in the continuous part of the budget, we need to just amend that by the amount of dollars that's required for the overlap, which, as you can see, is $13,648. So Robin prepared this, but it's really just making sure that we pay out of the right bucket in the budget. That's what we're trying to do.
Okay.
That's
Need a motion to approve?
So moved.
Moved and properly seconded. All those in favor?
Aye.
Item 6 is the fiduciary insurance review. This is Mr. Lieberman and Mr. Marox, Gabor, and Harvey.
That's what an attorney had. The name thing.
Good afternoon. My name is Gabor Moros. I'm the Assistant Chief Counsel, and the subject today is fiduciary insurance.
Gabor, before you continue, this is an information item.
Yes.
Okay, we're not taking action on this item today, so this is
Right,
informational.
and
in nature.
I will
Thank you very
speak
much.
to that.
Would you introduce?
As you recall, the teachers' retirement law requires the system to purchase fiduciary insurance for the board members, for the officials, and the investment staff members. And also the government code provides authority to purchase insurance, fiduciary insurance for the system and the plan. So in that context, we have what is called traditional fiduciary insurance. And our broker in the past 3 years was Alliant Insurance Services. They procure the insurance policies for every year. There is a renewal every year, so the current policy that expires at the end of June was obtained by Alliant Insurance. At the same time, our contract with Alliant expires at the end of June, so we started a new request for proposal process at the end of last year, and we invited bids. The search for a broker was driven by the concern raised by Mr. Rosenstiel that the coverage may not be the one that everybody believes is necessary for the system. So when we received bids, a panel was formed. Mr. Rosenstiel and I formed the panel who evaluated the bids, and we used Mr. Lederman as the advisor, technical advisor. We had interviews with the bidders, and we selected Aon Group, who is represented by Michelle Cowan here. She's a vice president of Financial Services Group of Aon. They started the search for a new policy already, but we thought that it was very important to bring the subject to the board. And the objective here today is to provide you a kind of education to explain what fiduciary insurance is, what is covered, what is not covered, and also provide you various policy options that are available. And along those lines, we set it up as an information item, not as an action item, but we hope that after the presentation and the discussion about it, you will provide us some kind of direction, what variations you prefer, and then we can start searching for that. And if it is absolutely necessary, we can still come back in the June meeting. There will be still sufficient time if you want to make a decision on a certain policy. Definitely, if we go over $1 million, we have to come back anyway. So these are the options. The presentation will be led by the Aon Group, and Mr. Lederman is here to provide expert advice on fiduciary law. Michelle?
Great, thank you. Okay. So as Gabor mentioned, we want to make this partly an information session, partly to talk about fiduciary insurance coverage, how it's structured currently, potential gaps that could exist in the way that it's currently structured, and how you can bridge those gaps with an insurance solution. And we're going to, in the course of the discussion, go through a couple claim scenarios so that you can see exactly how the policy would respond in a real-life claim scenario. And all of this is to help you make some key decisions that need to be made with respect to the renewal coming up and how to structure the insurance to best fit your risk philosophy, your budget, your priorities over who you want covered, what you want covered. So the key questions that you will need to decide on is who should be insured. Individual board members, fiduciaries, trustees, and staff members, or also CalSTRS and also the plans. Currently, all three of those are covered. But for purposes of what's mandatory under the statute, it's just the individuals who have fiduciary duties and who have discretion over investment funds, who have to be covered by the insurance, and the rest is discretionary. So we want to talk about the options with respect to who and what should be covered. What coverage options should be included? So there are various structural options that you can consider as you're looking at fiduciary coverage. Some provide broader coverage or more focused coverage. So we're going to talk about some of those options that you'll have as you look at the renewal. What's the appropriate retention? When we say retention, we mean essentially a deductible. So that's the amount that needs to be incurred on a claim. It's spent on a claim in defense costs or indemnity before the insurance policy will respond. So what's the appropriate retention for CalSTRS? How much insurance should be purchased? What limit of liability is appropriate? Waiver of recourse. It seems like a complicated term, but we're going to go through what that means and the recommendations with respect to purchasing that waiver of recourse. And then how much will the program cost? So all of those are key questions that will factor into your decision making on the fiduciary insurance. And underlying all of those questions are questions concerning your risk philosophy and risk tolerance. So what is your priority when you're buying fiduciary liability insurance? Is your priority individual personal asset protection, protecting the individuals in the event they're subject to a claim, and making sure that individuals do not have to come out of pocket for their own expenses for defense or indemnity. Another important component to that is attracting board members and keeping board members, making them comfortable with the fiduciary liability insurance that's in place so that they feel comfortable sitting on the board and making the decisions that need to be made with respect to their duties in that regard. What is your priority with respect to plan asset protection? Is it something that is necessary, something important to you? So that's another key question as you're looking at fiduciary coverage. The scope of risk transfer, what I mean by that is how much limit are you going to buy and how much of a retention or deductible are you going to self-insure, essentially. Another key question. And then program cost. Is there a budget that needs to be met where the insurance shouldn't go over that budget? If so, then you need to structure the program in a way that comes within that budget. And we can, adjust the limits, adjust the retention to meet those guidelines. So those are all key questions. So as we're going through the discussion, hopefully that will help you think about those questions and what the answers should be for CalSTRS. Okay. So wanted to start briefly just talking about the structure of the current insurance policy. So the fiduciary liability insurance is designed essentially to cover two things. The first is breach of fiduciary duty. And in connection with that, situations where an individual is claimed against or sued because of their status as a fiduciary. That's a major component of fiduciary liability insurance. Another component is negligence in the administration of the plan. It could be mistakes, could be gross negligence, could be other things that cause the plan benefits not to be provided appropriately. That could be more of a staff issue than a board issue, but the board or the staff could be the subject of a claim in that regard. So that's the basic premise behind the insurance and what it's intended to cover. The way it's structured is in essentially three parts. They don't name the three parts in the fiduciary coverage, but we're gonna name them so that for the purposes of discussion. So the first thing that your policy covers, and this is a three-part policy, but it's an aggregate limit. That means there's one limit, and any one of these types of claims can access the policy or erode the limit of the policy. So all three of these are covered. The first part that's covered is non-indemnifiable loss. And that's essentially situations where an individual is the subject of a claim and is not entitled to indemnification by the system. So it'd be a situation where indemnification is not provided and not permitted or required to be provided by the system. In those cases, the policy would respond from first dollar. So there would be no retention in those situations where an individual is not provided indemnification, not entitled to indemnification. The policy would respond from the first dollar, so the individual would not be responsible for a retention or deductible. Other examples of when that kind of coverage could be triggered is a bankruptcy, unlikely in this scenario, but again, a possibility. And there are certain circumstances where the statutory scheme does not provide for indemnification. It will specifically say indemnification is not provided in certain circumstances. Criminal acts in bad faith would be one example. In that case, the coverage would respond on the non-indemnifiable loss side, subject to the terms and conditions of the policy, of course. The second type of coverage under the policy is indemnifiable loss, and this is the most common type of claim, most common type of coverage that's accessed in a fiduciary liability policy. This is where individuals are the subject of a lawsuit or a claim, and they are entitled to indemnification by the system per the statute. Indemnification is permissible. Even if it's not provided, if it's permissible, it becomes non-indemnifiable loss. And we're going to talk a little bit more in detail about that in a moment when we go through the claim scenario. Those types of claims where indemnification is permissible or required are subject to the retention or the deductible in the policy. And currently that retention or deductible is $25 million. So the first $25 million would be the responsibility of the system in terms of its indemnification of defense costs and indemnity to the individuals. And after that 25 million has been satisfied, then the insurance would start to pay on the claim up to the limits of liability, which are currently 75 million. The other type of coverage within this same policy is coverage for the entity itself. So for CalSTRS and also for the plans. So, certainly CalSTRS could possibly be the subject of a lawsuit, particularly in administrative error type situations. And even in breaches of fiduciary duty, we sometimes see it, but but also the plans can sometimes be named as well. So in order to provide the broadest scope of coverage and potential claims, the policy includes all three. So any claim that we've just discussed could access the policy. The difference with the deductible is the claim indemnifiable or not? Is it able to be indemnified or not? That's what determines whether the deductible applies. There's no difference in the actual coverage between something that is indemnifiable or not, with the exception of the retention.
Michelle, let me, if I may just for a moment, cut in and try to paint a little bit of a picture here for board members in this situation to try to give you an idea of what's covered, not covered, and where the risk is. You're entitled, as board members, you're entitled to, you have immunity for most of your discretionary acts. When you sit on this board, you're immunized by state law. That's the way that people are encouraged to serve on these boards. And then you're entitled to, if a claim is made against you as board members for something carrying out the discretionary judgment that you exercise, you're entitled to indemnification. That is, you're entitled to have whatever loss any claim would have against you covered by the system. You're also entitled to your cost of defense covered by the system. The problem is that when people sue, those are called indemnifiable claims. It's ordinary course business. You're making decisions all the time. And the problem is that when someone makes a claim, someone sues you, they don't always put it in nice, neat boxes like that. They may sue you for breach of fiduciary duty. They may sue you for civil rights violations. They may sue you for any number of things. And then when you look at your policy and you look at the law of indemnification, you say, well, is that indemnifiable? It's not indemnifiable. And somebody has to make a call. So the real question, one of the big issues that we're dealing with today is who bears the risk of that call? Who bears the risk of a lawsuit or a claim being filed that names you personally, and suddenly you have to defend yourself? Do you have coverage, or can you get coverage? Is it appropriate for the system to make coverage available to you so that the first dollar that comes of cost when you have to go out and hire an attorney to defend you, that risk is shifted to a third-party insurance company as opposed to your risk being borne? That STRS may see it as indemnifiable or not indemnifiable. The insurance company may see it as indemnifiable. They may not agree. In that gray area, the issue is who should bear that risk, and can we transfer that risk to a third-party insurance company for a reasonable price, and is that appropriate for the system to pay for in the situation? So that's why you look at these nice, neat boxes, and they make a lot of sense in theory, but in my experience, in a lot of places, it's the gray area between when people don't agree what box it falls into, that the real cost and the risk has to be borne.
Thank you, Mr. Liederman. We have two board members that have questions. Mr. Unterman?
Yes. And the related question is mandatory advancement of expenses, because that's really where the battle is fought in most of these cases. So what I have a question about, and I'm sort of kicking myself for not knowing the answer, having served on this board for a while, is what is it that obligates or covers us right now as to automatic advancement of expenses and coverage of indemnifiable acts?
You have a policy.
Besides a policy.
That's what you have. No, not insurance policy. I'm sorry. You have a board policy that talks about what happens when a claim is filed against you. And the process is that it gets evaluated by the legal office and a determination is made as to whether it's mandatorily indemnifiable, discretionarily indemnifiable, something in between, or we don't have enough information yet to make that determination.
So
That's
in
all
every-
governed by the board policy.
That's interesting. In every other setting that I'm involved, there's either a bylaw or provision in the charter that says advancement is mandatory in all cases, subject to recoupment if you're not entitled to indemnity. But you're saying that's not the case here.
That's correct.
Would it be legally feasible to make it the case here?
Yes.
Tom,
Okay, I
what was
think
your
that-
point? Your point was in the other areas that you have this similar,
Yeah.
the coverage is,
It's an automatic, you're gonna get costs advanced. You may have to pay them
the
back.
individual will. So the
Yeah.
individual's not out of pocket.
Right.
Correct, okay.
And the individual gets to, or the board collectively, or similarly
Yes.
situated directors get to choose counsel. Okay, I think that's something we should address.
Anything else on that, Tom?
No, I
Okay.
mean, because that's 90% of the battle.
This exact point was raised in a 90 minutes, that exact point was raised in a 90-minute session and discussion at Rotman by a professor who serves on multiple boards. And he said that's at the crux of what, as a board member, you really want to get to the heart of.
Right.
Mr. Rosensteel.
Yeah, and this is something we've been discussing for a couple of years now, which is that we've got this gap. Both Michelle and Harvey and Gabor have been talking about this question of what if there's a disagreement as to whether it all works out beautifully if everybody agrees. You know, if everybody agrees it's indemnifiable or everybody agrees it's not indemnifiable. But if there's a disagreement, we're the ones, not just the board, but all executive staff, anybody who could be sued for carrying out their CalSTRS responsibility, that's where the gap is. And we don't have that protection right now with our policy. And that was the failure that has been discussed at this board now for a couple of years. I'm glad we're beginning to try to address it and consider a policy that can address that gap. But that's the biggest gap we have been facing. Tom's point is an additional good one, that there should be immediate advancement. But I mean, you know, we're right now at the point where you know, it could take 5 or 10 years for litigation to get settled and a judge to finally say, yes, this is indemnifiable, or no, it's not indemnifiable. And only at that point would we know whether the insurance company, which has a $25 million retention before they have to pay anything, or the system has to pay. So it's.
Well, even before that, I mean, the most common way to sue people and put pressure on them is to make some allegations that include non-indemnifiable claims.
Mhm.
And the common response from an insurance company is, we're not advancing money at all. And then our lawyers fight back and forth for 3 or 4 months and say, well, we'll sue you for failure to provide a defense. And finally, they agree to advance, but meanwhile, either your personal lawyers are very friendly to you and nice because they know the way this plays out, or you're writing checks one way or another. And that, it doesn't seem to me to be an appropriate position to potentially be in for a public service obligation. Now, my guess is it's a different situation for the public officials who serve on the board. And so that may be something to address as well.
If I may address that,
Right.
in what we're talking about here for breach of fiduciary duty or obligations to this board, there is no difference for the public elected officials and their designees. they are each as exposed in the same manner as all other members of the board.
Thank you, Mr. Liebman. Ms. Higa?
Thank you, Mr. Chair. I think I just have a question about the discussion we just had. So it sounds like there might be two solutions that we try to address. One being in terms of decisions around our fiduciary liability insurance coverage, which I think Paul, I haven't been on the board for the time period that you all have been discussing it, but that's a gap that we can seek to address. But then there might be an additional board policy that we might consider regarding the advancement issue, Tom? Okay, I just wanted to understand if there were two issues.
Yeah, those are the two key points. And as I understand, please correct me if I'm wrong, is this whole issue of the gap that exists. If we want to eliminate any gap, we just have to figure out at what price are we willing to pay to eliminate that gap. And that would be done with an outside firm. Is that correct? Is it?
That's correct. I would like to keep us off using the phrase gap.
Sure.
And talk about uncertainty.
Oh, that's good.
Because a gap is a little more definable, like a gap in coverage or something like that. What we're really talking about here is uncertainty. The being uncertain as to whether or not you're going to get covered and defended.
I like that.
So
I like the fact
that's what
that we
we're
could
really
have
dealing
greater
with.
certainty.
Greater
would
certainty
be
and
appreciated.
risk transfer. Who should bear that risk? And is there an appropriate price for transferring it to another person off of yourself as a public servant?
So let me just take one more question or comment from Mr. Zeiger, and then we'll go back to your presentation and we'll get back on. But those are two key takeaways of the presentation to date, and is being responsive to the work and the concerns that the committee has raised. Mr. Zeiger.
I like the gap argument.
Uncertainty, Mr. Zeiger. Uncertain. We're looking for greater certainty.
Because what it is good for, it seems to me, both the organization and for the individuals to be in the same place in the event of a suit. Because if absent some unusual circumstance in the world, and those things are there's always room for that at some point down the line. But what you don't want is for somebody suing to start picking apart a defense by working on the different vulnerabilities of the different parties, which is what you've talked about. And if you can do a unified defense, the organization's better off and the individuals are better off. If you set up a circumstance where it's easy to try to separate and divide the individuals from the group, then it seems to me it creates problems certainly for the individuals, but also potentially for the group as well, because Paul may want to settle up real quick and get out, right? And you don't want to set up a circumstance where that is an advantage for one board member or to the detriment of the institution. So making sure those things fit is, I think, really useful for both for individual board members and for the organization as a whole.
Thank you, Mr. Zeiger. So there's a little kibitzing back and forth, but on a more serious note, this whole issue of creating some greater certainty around potential litigation and the transfer of risk and at what price is critically important for this board to resolve. It's something that we've talked about for a while, and so at some point we have to make a decision. But it's this, it's a serious matter. So Mr. Unterman, and then I'm going to turn it back to our panelists.
And I know I'm reiterating it, but my every experience is insurance policies are insurance policies, and there's lots of litigation about who owes what and forever. But without mandatory advancement of expenses off the bat, we have a situation that's very uncomfortable for individuals to serve. And so I think as we revise this package, that must be part of it.
And as I understand that portion of it, that's an internal policy issue. So if I could ask the staff to please make note of that issue, and then we can discuss how to what extent we have to address that. If it's an internal policy issue that Mr. Unterman's raising, let's talk about what we need to do going forward to that matter is addressed. Okay, back to you. Thank you.
So I guess just to comment on some of the commentary that, and some of the questions that have been raised. The insurance policy itself, you're correct, doesn't determine what is indemnifiable. It essentially is going to look at the indemnification provisions that are in place in the statute or in the board documents or the documents setting up the plan, and then make a determination based on that. They're going to let you show them what you think it should be, and they're going to say, well, that clearly is, mandatory indemnification or permissive indemnification, so it's not non-indemnifiable, and then the retention applies. Mm-hmm.
I hate to be a broken record on this, but insurance policies vary about advancement of expenses too.
Yes, they do.
Yeah. So we have to be talking about a universe that covers advancement.
Just specifically going forward through the continued presentation, one of the items that was recommended to us related to this issue was, in fact, when in fact we make a decision on what we want to do, that the board members all get a hard copy of exactly what the policy is, exactly what it says, and exactly what it doesn't say. That we need to have a copy. That was one of the recommendations from Rotman. So we'll make sure we'll do that as well. So back to you.
We thought it would be helpful just to run through a claim scenario to show you how this could happen. And I think Harvey has already given you a glimpse of how a problem could arise, but let's just take a real scenario and see how that would play out. So this flow chart will just show you what decision points push the policy either to have a retention or not have a retention. So I'm going to use a real life claim example of a situation where there was an allegation of an imprudent investment. So this happened in Michigan. There was an investment of $10 million in one investment that was 20% of the plan assets at the time for this particular plan. And the board was subsequently sued for breach of fiduciary duty, among other things, for making that imprudent investment or authorizing that imprudent investment. It was a loss of $3 million in this case. That seems very small, for an organization like yours, but just to give you an example of what kind of a claim that you could see. So the individual board members were sued. Let's just turn this over then to CalSTRS. Let's say CalSTRS, as the board has been accused of making an improper investment, imprudent investment of some magnitude. And the individual board members end up being the subject of a lawsuit, and perhaps CalSTRS staff as well. In that case, both in the way your fiduciary policy is currently structured, the staff members and the board members are both insured under the policy. And the policy would cover breaches of fiduciary duty that were alleged in that type of claim. Then the first question is that claim indemnifiable? So it depends on the allegations of the claim. It's what we were talking about and how the claim is pled. Does it include allegations of misconduct, fraud, or criminal activity, or gross negligence, or something that's other than breach of fiduciary duty? Depending on what is alleged, your indemnification provisions may respond differently. Generally speaking, you are entitled to indemnification for actions brought against you, but there are certain exceptions if it's outside the scope of your employment, if it involved actual fraud, corruption, or malice. So there could be potential allegations in the claim which would make it a questionable result, whether you get indemnification or not. So my understanding is that the general counsel makes that determination, and then you would provide that to the insurance company, your answer, whether you are indemnifying or not. So this is a question: is it indemnifiable? If it's permitted or required to be indemnified, then it's indemnifiable, even if the indemnification is refused. So it could be a claim where you're entitled to indemnification. It's not fraud, not malice. It's in the scope of your employment. seems like something that should be indemnifiable, but for some reason, indemnification is denied. We have seen that happen, or it could be that the allegations of fraud or malice, et cetera, are so questionable that they don't provide the indemnification while they try to figure out whether they should. In any case, you're not provided indemnification. That situation is still, under the policy terms, indemnifiable because you're permitted to be indemnified pursuant to the statutory scheme. So in that case, you go over to the yes box. Yes, it's indemnifiable. What that means is the 25 million retention or deductible applies to that claim. That means the insurance policy is not going to respond until $25 million have been incurred on that particular claim, either in an indemnity or defense or both. And if you as board members are not provided with indemnification by the system, then you are at risk, your personal assets, to pay for your defense expenses or indemnity up until that 25 million retention has been eroded. And at that point, the insurance policy will respond. But that's what we're talking about in terms of, we're talking about not a gap, but uncertainty, right? Uncertainty about whether you'll be indemnified or not.